COVID-19 has really created this renewed sense of urgency for elder law planning. I'm with Foster Swift attorneys Nick Camargo and Matt Fedor. And Nick, I want to start with you to talk about, in this time-sensitive situation where our seniors are most at risk, what are some things that we really should be focusing on right now when it comes to elder law planning?
You know, Julie, I've been asked that a lot, believe it or not, over the last 30 days. Like you said, so many people have grown concerns about what is in their plan, what do they have situated, what do they need to have situated. And those conversations stem from the reality of what we're dealing with. And that reality is that we might find ourselves in a situation where someone's going to have to help us out. What we're talking about is all of your estate planning documents. Now, there may be some that are slightly more pressing at this point during the COVID pandemic than others, but really they all are important. And what they include are trusts, so that your property can be properly managed if you need to, if you're incapacitated or if you pass. Wills, which are in our world set up primarily as safety nets for a trust. But again, that help you manage your affairs. And then one of the questions I get the most is about health directives, healthcare directives, healthcare powers of attorney and advance directives. I get asked about living wills. Michigan doesn't have a living will, but we generally have that idea. And those are the documents that allow us to inform our loved ones what type of treatment we want and who we want making decisions for us should we need that treatment. Financial documents, including the financial power of attorney, are so important right now. You have so many people that are being hospitalized and unable to care, and then they, for the lucky ones that come out of it, it's taking a week or 2 weeks. And what's happened with their stuff in that intervening time period? It's important to have your affairs in order, and it's important to have the people that you want taking care of your important affairs also in order. So those are some of the documents that we recommend and that we're seeing people ask about right now.
I've also got some questions about how do you update your estate plan during this time? That's always a challenge right now with the stay-at-home order and the difficulty in getting together to sign. So in addition to what Nick's saying about this is a great time to review all those documents if you've got them currently, and make sure that they still express your intentions and that the individuals that you've appointed are still the people you want to be in charge of your stuff and take care of you if something were to happen. Reviewing all of those right now during this time that we're in the stay-at-home order is imperative and can be very helpful. If there is a situation that you find yourself in that you need to make a change, then you should obviously contact the attorney or an attorney to discuss that and see the best way to effectuate that. But one of the things we've seen is or one of the tools that we have in Michigan is you can write a holographic will, and a holographic will is a will that's written in your own hand and signed by you. And so, we could help you and direct you in that regard on how to effectuate that. We do currently, under one of the state's executive orders, have the ability to do remote notarizations. If there's an emergency situation, somebody's in a nursing home, or they need something done immediately, under the current executive order, we can do remote notarizations and remote witnesses. There are several steps that need to be complied with, so you want to make sure that you're going to someone with the knowledge and ability to do that. But definitely, emergency circumstances are going to come up right now. Review. If you need to make a change, talk to an attorney about how to effectuate that as best you can. But really just kind of thinking through, what do I need to do when this is over? Maybe consulting with your attorney and going in and reviewing your existing estate plan would be a great use of the time as soon as the stay-at-home order is lifted.
Mm-hmm. You mentioned durable powers of attorney, which I think are top of mind right now for some people as we're dealing with this healthcare crisis. What are some of the things that we need to consider when we're selecting representatives?
Well, selecting someone who is going to manage your healthcare decisions is always tricky, right? You need someone who understands you. You need someone who is going to be strong enough to carry out difficult decisions. And you need someone preferably that's close and that's going to be able to access whatever documents they need to access in order to help out your medical care professionals. I usually, it's interesting because I usually, when I talk to clients about it, and I've had, like I said, several clients call since this pandemic sort of went into place. And for the most part, with the healthcare power of attorney, at least, people are pretty comfortable identifying that person in their life or those people in their life that they think are going to make the best healthcare decisions for them and that are going to be the best equipped to carry out their own personal healthcare decisions. Certainly, to answer your question now, just in summation, you want someone reliable, you want someone who knows you, and you want someone really that you can trust.
Yeah, Nick, I think you're 100% right there. One of the conversations I like to have with my clients when you're picking any fiduciary, and the fiduciary, is obviously somebody who's going to be acting on your behalf if you cannot do it for yourself. When you're picking any fiduciary, there's a couple basic tenets that you need to make sure. You need to make sure the person's trustworthy. You need to make sure that the person has the ability to carry out your wishes and understand your wishes. And then you want someone who's going to be able to communicate with the rest of the involved parties, again, to alleviate any potential issues from a communication standpoint down the road. All the family members want to be involved and know what's going on. And to the extent that, a simple communication can prevent problems or ill will, that person needs to be able to facilitate that. But it's pretty clear that's one of the benefits of writing down your intentions through the documents. You're communicating your intentions through the documents to the individual who you're asking to do it. So there's not a whole lot of wiggle room. They may have a different methodology of getting to the end, but you're going to communicate to them whether you want life-sustaining treatment, whether or not they can, pay themselves in the fiduciary capacity. All of those things that are written in the documents are what they're going to be carrying out. So when you're picking a fiduciary, you just want somebody you can trust, who's knowledgeable, and who has the intelligence to follow the rules that we've set forth.
When we're dealing with a pandemic like this, I think a question that comes up is about reviewing documents. How often should we be reviewing our documents, whether we're in an urgent situation like we are now or just in general? How often do I need to look at my documents?
Julie, that's a great question. And Matt and I, for a long time doing this, have felt that if you don't review your documents, if you don't do regular maintenance on your documents, if you don't at least know what's going on in your documents, then your documents lose their efficacy, okay? So they won't be able to help you in the manner that you thought they should be helping you when you first execute them. I normally tell my clients, and I think Matt and I are about the same with this, that I tell them every 2 to 3 years, I'm going to send you a little letter. It's going to say, hello, how are you? How are things going? And should we have a discussion, right? And so, do we need to do it every 2 to 3 years? If nothing's changed, sometimes all it takes is a 5-10 minute phone call. Everything's great. Yes, this is who we remember is in charge. But sometimes in a 2 to 3 year period, a lot might have changed. You may have acquired new property. Perhaps the person that you chose to be your personal representative as far as your estate, or the person you chose to manage your health decisions under a healthcare power of attorney, maybe they've moved to California or something, and you just didn't think about it. So I think at least every 2 years to touch base is a really good idea. And then certainly anytime you have a concern, anytime you realize it's been a while. I tell a lot of people a story that I had early on in my career where I met a woman and we were going to do a total overhaul of her estate plan, redo all her documents. And as we were going through and reviewing her documents, I mentioned the person who was her trustee. And a trustee in Michigan and across the states is the person that you've trusted to manage your affairs under a trust. They're probably the most important person when it comes to any particular estate planning document related to assets. And as I reviewed the documents with her, I mentioned the name of this individual who was her trustee, and she looked at me and said, oh my gosh, I haven't seen her in 10 years. I don't even know where she lives. I think she moved out west. So certainly 10 years is not a good amount of time. You need to do it more often whenever you have changes. And then during this COVID pandemic, it's always a good idea. I've had so many clients reach out and just say, hey, I want to make sure all my affairs are in order. I want to double check. Just anytime you sort of get that feeling that maybe something is off, it's a good idea to review. But, 2 to 3 years is our general rule of thumb.
In addition to that, I think the other logical time to have your estate plan documents reviewed is when you have a life event. You have a new child born, you have the death of a family member, a divorce, or something, some life event that may cause a change in who you've selected to take care of your or manage your affairs if you cannot. I think those are the general times when you review it. But one of the other things that I think is necessary, it's not just a review of the documents. When Nick and I meet with clients, there's really three parts to the estate plan, right? There's the documents that we draft, which are the directions that we're giving to our people. There's the funding of the estate plan, which is making sure the beneficiary designations are up to date. You've got correct titling. You've got any joint assets are titled correctly. And then the most important part, and the part where I think a lot of attorneys fail, is in the follow-up, and that is like Nick said, every 2 to 3 years, reaching out to the client or the client reaching out to us and just having a conversation, at least, maybe not a meeting, but a conversation to say, hey, is there anything changed? We can ask you the right questions to know whether or not it's time for a full review. So, but that last part, the follow-up, it's not uncommon for Nick and I to get a client to come in, a new client, and they're showing us a trust or a will that's 20 years old. They did it when they first had kids, haven't looked at it, haven't touched it since then, and now they're getting ready to retire, and they're saying to themselves, oh, I should get this in order. So really, it's that last part. You got to have the first two, the documents themselves, and then the making sure the estate is funded correctly. But the last part, that's the key. That's really how you make sure that all that investment you made before in time and money really does work for you when you need it.
Where should I keep these documents, and who do I need to be telling about my estate plan?
Well, that's a very common question, Julie, and there's really no right answer. The one thing I'll say is you want to keep your documents in a safe place. Your attorney should have a copy of the documents. That's, I think, a given. Most attorneys will keep a copy for their records anyway. And then you want to put your original documents in a safe place and tell somebody where they're at. You definitely want to make sure that your family members know where they can access those documents if necessary. One of the common questions I get almost every time is should I give these documents to my kids, or should I give these documents to a family member? And our answer is always no. You don't need to give it to them. What you need to do is tell them, hey, here's my attorney's number. If something happens to me, they've got the latest and greatest and updated document. Because the problem is if you give them a copy and then something happens down the road and you change that document or you change the fiduciary, it can be a very awkward conversation. A couple of times in my career, I've had people call me up and say, oh, so-and-so passed away. I'm their successor trustee. I need to make an appointment with you. And we'll say, okay, let us review the file. We look at the file and I realized that they had actually written that person out. They were no longer the fiduciary. So that's a very difficult conversation to have with that person, where they're expecting to come in and help, and they don't have any rights to even see the documents at that point. So definitely be careful if you're going to give out copies of your documents. Understand that if you do that, any subsequent changes, you should also provide them with updated copies of that. Or you can just give them your attorney's number and say, look, this person is the one to contact if something happens.
And Julie, I can't agree enough with Matt on what he just said. We stress, as we've talked about through a lot of our series and different presentations that we've provided, we've stressed communication. As elder law attorneys, we really, really believe in that. We think it's important. But we also recognize, and it's something that we are uniquely able to help clients with, we recognize that there are certain times when communication with all members of the family may not be possible for whatever reason. Not every family is perfect. In fact, no families are perfect. And so when we go through and discuss these things and talk about that communication, It's really important to understand that there is no one-size-fits-all sort of plan of attack when it comes to who should have my estate planning. I personally believe at the very least that the fiduciaries should know and should be apprised that, hey, listen, as Matt has mentioned, this is who I've used. The more people we can get with knowledge of that, the better. Handing documents out, as Matt said, is something that I generally advise against. I can't tell you, doing the amount of litigation that we do, I can't tell you how many times a child who has seen something change, that they sort of link to that, and it justifies their position because an old document said A, B, or C. So the new document that says X, Y, or Z must have been the result of undue influence, or must have been the result of coercion or fraud or something. So handing out those documents is not really advisable, but communicating in a way that you feel is going to be appropriate for your family members. It's awesome. It really is awesome when you get a family that can communicate openly. And I encourage that when you can, but it's also realistic to find families that maybe that's not possible. So you really have to work with someone like Matt or myself or another attorney who specializes in this area and has dealt with so many families to know what is the right plan of attack for your particular situation.
Communication is a theme that continues to come up. So certainly key there. Matt and Nick, thank you so much for offering your insights on this topic. Of course, elder law planning right now with some renewed urgency during COVID-19. Thank you both so much.
Thank you, Julie.
Thank you, Julie.
For more information on elder law planning, head to Foster Swift's Elder Law blog at mielderlawblog.com.